Good morning, good morning, good morning again, folks. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We're going back to that horrible world known as the JRC. But before we do the usual disclaimers, I again apologize for my appearance, folks. When I'm doing these videos in the morning, the last thing on my mind is what I look like. I know some of these I look pretty haggard, so I apologize for that. All right, folks, if you are new in regards to the situation at the Judge Rotenberg Center and other places like it, please, by all means, go into the description box. You're going to see all the pertinent links to the Stop the Shocks campaign, as well as the links in regards to protection against restraint and adversives. All right. You're going to see links in regards to the JRC, the NeuroClastic situation where the JRC is threatening them with a defamation lawsuit and their GoFundMe. You're going to see links in regards to the Agape boarding school situation. Please read and go over them, all right? All right, folks. When we discuss places like the JRC, you're going to hear vivid descriptions of and catch clips or surveillance footage of people with disabilities and mental health issues being abused. If you do got young children present, headphones, all right? The channel here is marked not for kids for a reason because we do use profanity on occasion and speak on dark subjects. So if your child is 16 and younger and they are watching this, highly unlikely, but in the small chance that they are, parental supervision is advised, all right? Also, folks, I am literally bleeding viewers. I'm not really surprised. This isn't the most popular subject in the world, but if you are indeed actually watching these videos, please double check and make sure that you are still subscribed to the channel. All right? Okay. Let's go on to where we left off. However, in one case, Malanis versus Williams, the 10th Circuit Court of Appeals found that the state involvement with a private educational and detention facility for troubled youth was significant enough to enjoin several facilities' practices, including the regular, largely punitive use of restraint and seclusion under 1983. So this is one particular case here where a court actually did its job. All right. The problem is when the laws that are currently on the books, when there is so much left up to interpretation, it really becomes a contest over who has the better lawyers, not if the protection laws will actually protect the students. Okay. This is why we got to get more specific in our language. This is why certain laws need to be amended so that they can be more specific. Because it should not be determined on whether this kid is able to be protected or not, as to whether or not the family in question can afford better lawyers. Because that's what we have right now, folks. And if you don't believe me, the JRC still exists and is grifting off of us every year. The defendant in the case, Provo Canyon School for Boys, Provo Canyon, did not only receive significant amount of financial support from state agencies, local school districts, and federal funds, but also was support from state, but also subject to extensive regulations. Photobomb, folks. Good boy. But also was subject to extensive regulations specifically on the treatment of students in residential programs. So this is one of the schools that are notorious and is well known in regards to those who are fighting the top teen industry. It's one of the bigger cases that was out. The problem is, once again, you're dealing with, in situations like this, it's more of a contest between who's got the better lawyer more so than it is to actually protecting the rights of the kids at the school. And why that is the laws that are on the books are not specific and detailed enough. Again, it leaves enough holes open for interpretation to drive a diesel through, okay? Moving on. Finally, Provo Canyon entered into numerous detailed contracts to state concerning its treatment of students. These factors, in the court's view, constituted a state concerning its treatment of students. These factors, in the court's view, constituted a sufficiently close nexus to establish state action under 1983. In addition, it held that the coercive and unnecessary use of restraint and seclusion, among other things, amounted to the violation of the Provo Canyon students' substantive due process rights under the 14th Amendment, and enjoined these practices to the extent they were not being used in response to emergency situations. Again, what constitutes an emergency situation in these federal laws? I can't tell you because the law is too vague. You see where the glaring elephant in the room is in regards to using these as a defense against places like this? They're not defined enough. Okay? This is how you end up in situations where some schools will get called out on this and some won't. Like the JRC, for example. What makes it even harder is when you have places like the JRC that have a significant amount of power in their state. You're talking corruption, folks. Corruption. All right? On a massive scale. Massive scale. Until we get these laws to be a lot more specific, especially in regards to what constitutes an emergency situation, those laws being open to so much interpretation screws over people like me whose parents were not born with a silver spoon in their mouths. Right? Let's read forward here. Since the Milanos case was decided in 1982, though, few courts have decided to follow its lead. See what I mean? In particular, the Circuit Court of Appeals and Robert S. versus Stetson School explicitly criticized and rejected its holding, ruling that the 10th Circuit had given undue weight to the fact that Provo Canyon had been state funded and regulated, however extensively. Here we go again, but here's the facts, folks. They're not really. Because when you're in a situation like JRC and you have things like the consent decree, the infamous consent decree on the books, and you are JRC and you own the bulk of the judges of the state. Yeah, you see the problem when you leave laws like that open to so much interpretation? Means that so-called protections we have on the books don't in reality actually exist. That being said, the conduct complained of in Stetson was also not found to be state action because it was an individual instance of maleficence by a staff in violation of program policy. By contrast, the conduct at issue in Milanes was a known part of the program to which a child's parents and, esteemedly, the schools and courts placing children there knew of and consented to. Here we go again. Our consent doesn't matter to these folks. Okay? A good majority of these folks, consciously or unconsciously, do not really look at us as full functioning human beings with human rights. If we're lucky, we're looked at as third class citizens, folks. I hate to be the bearer of horrific reality, but that's how it really is. Okay? That's how it really is. The idea that they are consenting to this is not true. Those of us who were our own guardians, do not consent, and therefore don't get sent to places like this. But when you're talking about kids, yes, even 18 and older who fall under a guardianship conservatorship situation, we get no say. Our parents' human rights are respected. The school staff's human rights are respected. Ours are not. Okay? That is the other elephant in the room. Okay? This distinction is also significant in other cases that led to court decisions that departed from the holdings in Milanes. It is unclear whether a program's systemic use of aversives similar to that at Provo Canyon would lead a court today to find liability under 1983 if there was a significant amount of state involvement with the program. The outright refusal of a number of courts to follow Milanes suggests that it would not, but it remains an open question. Milanes is still considered good law. So what are we learning from these series of videos this morning? It's very simple, folks. These laws have been on the books, open to too much interpretation for too long. These laws do nothing, zilch, nada, nothing to protect the human rights of the students that are in question here. Arguments can be made that the parents signed off and gave consent to these aversives. So no matter how horrific those aversives are, the parents signed off, and therefore, yeah. See where I'm going with here? Pretty much means protection of the actual student in question is not respected at all. At all. Okay? This is how they continue to write off torture as treatment, and nobody really can do anything about it. Because the protection laws that are in place that many lawyers have tried to use are open to way too much interpretation. And as long as somebody with a bunch of letters behind their name signs off and the parent signs the consent form, it doesn't matter if they're violating our rights left, right, and center. These laws do nothing to protect us. Nothing at all. So what's the answer here? Well, I've been saying it all morning, folks. It's really quite simple. The laws must be amended. The language must get more detailed and specific. Protections have to be put in place within these amendments that will actually protect the best interests of the child, not the best interests of the school, not the best interests of the state, not the best interests of the parents, but of the student. Until that happens, places like the JRC will continue to torture generation after generation after generation of disabled people with impunity. Now, what can you do about it? It's very simple, folks, because this is never going to go anywhere. As you can see from over the past 40 years in places like the JRC until the outside world starts getting involved. You need to be calling your senator and congressman. You need to be showing up at their offices. You need to be writing bills and grants and what have you. We need you as a part of the grassroots campaign that's been going on for decades. Because the fact of the matter is, folks, the people in the outside world don't care what disability advocates have to say. I hate to be this blunt. But the reason why places like ADAPT are able to get the laws changed is because they are able to utilize and weaponize the idea of civil, basically nonviolent protests, civil disobedience. Because by doing those acts out there in the real world, it draws the attention of those who are usually not a part of these issues. And ADAPT should not be out there alone doing this. We, ASAN, NeuroClastic, Unsilenced, all of us should not be out there on our own. And the best way to start getting the attention of the outside world is taking a page right out of ADAPT's book. We're going to close on that, folks. We don't get very many views on this channel. The few that we do tend to get removed from time to time. So please don't forget to hit the like button, hit subscribe, and don't forget to hit the comments. I do appreciate your time this morning. And as always, folks, we here at Spilling Tea do hope you have a good one. Bye-bye, everyone.